few subsections of this, but feel free to stop me at any point. As Ashley said, put questions in the chat. I'll also make sure to leave time for questions at the end. See if I can get the slides to cooperate here. Also, I have a 2-year-old niece who's in daycare, and she gave me a bit of a cold, so bear with me as we make our way through this. So starting just with the Fair Housing Act, what exactly does it prohibit? And I know there have been a series of conversations so far, so I won't go too deep into this, but the Fair Housing Act, of course, prohibits discrimination in housing and housing-related services and transactions on the basis of several protected classes, which include race, color, religion, sex, national origin, familial status, or disability. And of course, there are state or local protections that may have additional protected classes. Some places have marital status. They explicitly cover sexual orientation, for example, veteran status, but these are the federally protected classes under the Fair Housing Act. The Fair Housing Act, in addition to protecting or prohibiting explicit discrimination against individuals or groups of people, it also prohibits retaliation. So someone who has made a complaint of discrimination, someone who has assisted someone else in making a complaint of discrimination, and has had some type of adverse action taken against them, that would constitute retaliation, and that's also prohibited. What's interesting about the retaliation provisions of the Fair Housing Act, which we'll get to in a little bit, is that it's an independent standalone claim. So even if there's an underlying claim of discrimination that isn't sufficiently proven, if you can prove retaliation, that's still a violation that someone can be held liable for. And the Fair Housing Act applies to most types of housing, but there are a few exemptions. One is for owner-occupied units or owners who have less than 4 units. There's also certain single family housing that's rented out by the owner that is prohibited and then also are exempted, and then religious organizations or private clubs as well. So that's kind of the umbrella under which we're talking about these gender issues, and we'll talk more specifically about the provisions of the Fair Housing Act that relate to gender discrimination. So the 3 topics I want to cover today are sexual harassment, nuisance and crime-free ordinances, and the Violence Against Women Act. We'll take each of those in turn. And again, I'll leave time for questions at the end, but if we get to the end of a section and you'd rather ask your question right then when we're talking about it, please feel free. I do have access to the chat and I can see your question. So starting with sexual harassment, I think this is the type of gender discrimination that people most commonly think of when it comes to the Fair Housing Act. And there are 2 different kinds of sexual harassment. We've got hostile environment and quid pro quo. So hostile environment harassment refers to unwelcome conduct, and the key here is that the conduct has to be sufficiently severe or pervasive to interfere with the use of that housing. So that includes the availability, the sale, the rental, or the use of that dwelling. And there are important things to note here in terms of how the courts have evaluated that severe and pervasive language. So usually a single incident may not be enough to constitute something that really interferes with the use of housing, but there can be single events that are severe enough that would warrant that. So, trigger warning here, but a single event that would be severe enough would be a sexual assault, for example. And again, this violates the Fair Housing Act, even if there's no eviction, increase in rent, even if there's no, typical adverse action taken as it relates to the housing, but making that environment so hostile that someone interferes with someone's ability to feel safe and secure in that housing is enough to constitute a violation. So I also have some examples here of what courts have held to be hostile environment harassment. That includes making unwelcome and lewd comments about a resident's body, touching intimate body parts without consent, repeatedly sending unwelcome explicit text messages and photos. And importantly here, this does not just extend to landlords. A landlord or property owner can be liable for hostile environment sexual harassment, even if they are not the one creating the hostile environment. For example, if they are made aware of a neighbor that is sexually harassing another tenant and they are made aware and choose not to do anything, they can be held liable for that harassment. They also can be held liable for the sexual harassment of an employee. So think of a maintenance staff or leasing agent, property manager, things like that. The second type of sexual harassment is quid pro quo. So quid pro quo is basically requesting sexual favors in exchange for services. So an unwelcome request or demand to engage in conduct where submission either explicitly or implicitly is made a condition to accessing, maintaining, or the terms and conditions of housing. So I'll say when I was working here in New Orleans, we saw a lot of these types of complaints, particularly after a natural disaster, such as a hurricane or flood, where tenants were requesting repairs and landlords were requesting sexual favors or making sexual comments in exchange for those repairs being made. Okay, I see a hand up from MCJ.
Yes. Sarah, is there any way that you could just slow down just a little bit?
Yes.
Okay.
Okay, so again, we see this a lot with repairs needed after storms, for example, where landlords, tenants would say, okay, our fence is down, or we've got flooding, or we need a new door, new floor, new roof, etc. And landlords would request sexual favors in response. So again, some of the examples here, demanding nude photos in return for approving a rental application, sexual favors in return for making repairs, evicting a person because that person refuses to engage in sexual conduct, or offering to exchange sexual favors for rent. That last one we unfortunately saw a little bit of during COVID, like the height of COVID, where people were not able to work, were behind in rent, maybe did not have access to rental relief services, for example, and landlords definitely were trying to take advantage of people in that situation. One thing that's important to note when it comes to sexual harassment as an advocate, it's very, very difficult to get people to come forward about these situations. There's a lot of shame surrounding it. There's a lot of people who tend to blame themselves for, feeling like they put themselves in that position, even though they had no fault whatsoever. And there are a lot of landlords that unfortunately are willing to take advantage of people. So this is a situation where we really had to train, particularly our intake staff and our attorneys, on how to engage with people who have experienced trauma to make sure that our office was a welcoming space for them to feel comfortable to share what happened. And it can also be difficult to get people who've experienced sexual harassment to want to continue with the process. It can feel very invasive having to tell your story over and over again, having to tell your story to a HUD investigator, for example, who maybe, is acting as a neutral and may not come across as very understanding, to potentially have to tell that story in a deposition and be cross-examined by a defense attorney. So there are a lot of things in terms of how to be an effective advocate around sexual harassment that I think are unique to this issue and don't necessarily come up in other aspects of doing discrimination work. So it's important to have those conversations if these are the types of cases that your organization is taking on. So in terms of liability for sexual harassment, there's both direct liability and vicarious liability. So direct liability is what it sounds like. It applies directly to an individual's own conduct. So that specific person, the property owner, property manager, their failure to take prompt action to end a discriminatory housing practice when they should have known or knew of the discriminatory conduct, or if the landowner or property owner conducted the discriminatory conduct themselves. So if they actually did the sexual harassment, they're directly liable for their action, but they are also directly liable if they knew about the issue and didn't do anything about it. And usually that action is supposed to be prompt, so having some type of investigative process that occurs quickly, interviewing the parties, taking notes, reviewing any security footage, reviewing any other types of evidence, and it's important that, again, the Fair Housing Act is very clear about retaliatory action and wanting to ensure that people can exercise their rights. So that action that's taken, that prompt action, cannot include penalizing or otherwise harming the person who's making that allegation. So if a report of sexual harassment is made against a maintenance person or a leasing agent, the landlord cannot say, okay, I took action by evicting the tenant, and that's how we resolve the issue. So the person who has allege the discrimination, there can't be any adverse action taken against them as a way to address the sexual harassment. Then we also have vicarious liability. So vicarious liability just means you're responsible legally for the actions of somebody else because they were your agent, they were your employee, and that can happen regardless of whether the individual knew that the harassment was happening or not. So that, again, the specific language in the regulation is vicarious liability includes liability for discriminatory housing practices committed by the person's agent or employee, regardless of whether the person knew or should have known of the conduct. So those are kind of the distinctions made there. And again, this includes all types of agents on behalf of the housing providers. But basically, if you're a housing provider and either your staff or you know of discrimination that's taken place, can be liable for sexual harassment. And then again, we've talked briefly about retaliation, but just to make it really clear, we consider retaliation a act of harm or some type of adverse action that a housing provider has taken against an applicant or resident because they've asserted their fair housing rights. This type of complaint can be formal, can be informal. There's no specific requirement that the complaint be made in writing, although we would always advise, as lawyers, we always advise complaints to be made in writing so that you have a record of the complaint was made, who it was given to, the date, and all of those things. And again, as I said before, retaliation is a standalone provision of the Fair Housing Act. So let's say I allege sexual harassment against a housing provider. I say that the housing provider touched me inappropriately. Even if we get all the way through a HUD complaint process, and then they evicted me because I made that request. If we get all the way through the complaint process and I can't prove for whatever reason that the actual sexual harassment took place, but I have an email from them where they say, oh, because you filed this complaint, it's easier for you to just leave. We're going to terminate your lease or we're going to evict you. They can still be held liable. I can still get damages. They can still be, found to violate the Fair Housing Act for that retaliation alone, even if that underlying complaint has not been fully supported. And importantly, a lot of housing providers get kind of scared about retaliation provisions and they try to use that as a excuse to not address anything, and say, well, we don't know what, we don't know what we can do and what we can't do. But a housing provider is still free to and well, frankly obligated to take appropriate actions to address sexual harassment, whether that's putting new policies in place. And even though retaliation is prohibited, that doesn't give anybody who's a tenant kind of carte blanche to do whatever they want to do in violation of regular rules. So you can't evict somebody because they filed a fair housing complaint, but if someone, is behind on rent or if they violate any other common rules and their provisions of their lease, it doesn't give kind of a get out of jail free card for that. It just means that you can't have any adverse action taken against you simply because you made a Fair Housing Act complaint. Okay, I'm gonna grab a little water. Okay, before I move on to nuisance and crime-free ordinances, are there any questions about sexual harassment? I don't see any in the chat, but I want to just give a second in case anybody has anything.
And if you have any questions, if you raise your hand, I can allow you to unmute yourself, or you can type the question in the chat before she moves on.
Going once, going twice. Okay, cool. So we can move on to nuisance and crime-free ordinances. And I won't spend too much time on this because it's kind of a niche issue, but I do think it's really important when we're talking about gender because there are aspects of nuisance and crime-free ordinances that have a disparate impact on women. So we'll start with just what are nuisance and crime-free ordinances? The slides will cooperate. There we go. So there are approximately 2,000 municipalities in almost every state that have enacted some type of crime-free ordinance. And they vary in terms of their format, but the basic gist is that they place limits on calls for law enforcement to a particular property or unit. So sometimes it'll be 3 strikes, sometimes it'll be 2 strikes, sometimes it'll be 4, sometimes it'll be a certain number of calls within a certain period of time. But once that property or unit has reached that threshold, they can be declared a nuisance. And the city can or municipality can then tell the landlord that they have to take any number of steps to address that nuisance. And that can be anything up to evicting the tenant. So there's one version, limits for calls on law enforcement services. So that's 911, it's calling for an ambulance, things like that. There are also versions that deem certain activity to be a nuisance. Let's see. Oh, I do see a question here. Can you address retaliation issue even if the allegation is proven to be false? So yes, so let's say I make a false claim of sexual harassment, which we would obviously not advise. If I make a false claim of sexual harassment, the landlord doesn't necessarily know at that time that that is false. They still have a duty to investigate that claim and determine whether or not the sexual harassment took place. I still have a right to file that complaint for for HUD or whoever to investigate and determine whether or not that took place. If I file a complaint and the landlord takes action against me, because I filed that complaint, they still could be liable for retaliation, even if HUD comes back and says, okay, this person made a false complaint, this complaint is not true. If they take adverse action by trying to evict me or they, impose other types of bad conditions on me as a tenant before that complaint has been resolved, they can still be held liable for retaliation. Okay, hope that answers your question. If not, we can definitely follow up. Okay, so additional version of a nuisance or crime-free ordinance deems certain activity as a nuisance. So sometimes that includes, some type of physical violence. Often it includes any type of law enforcement response. So the difference here is whether or not you call the police or not. The first one you're thinking, you can think more like, okay, I'm the victim of a crime. I call the police. That might count against my three strikes. The second one is if something occurs on the property, I'm attacked on the property for whatever reason and somebody else calls the police, that can count as well. And sometimes they even require the eviction of a tenant, even if they were the victim of a crime. And then you've got the crime-free ordinances that are specifically related to crimes. Nuisance activity is kind of broad, which is, as a lawyer, always that type of discretion always leaves room for problems, I would say. Crime-free ordinances are a little more limited just to criminal activity, but a lot of times any criminal activity on the property and sometimes even off the property is automatic grounds for eviction. So, for example, one of these ordinances I had heard of, a 14-year-old boy, I believe he was caught shoplifting at a mall, across town, and the landlord used that type of ordinance as a way to evict his entire family, even though the criminal activity was committed by a juvenile and allegedly committed by a juvenile and also didn't even take place on the property itself. So these types of penalties for the penalties under these ordinances can range significantly. There are some versions where the penalty is tied to a rental license. So there are versions where, for example, if you need an occupancy permit to rent a unit, you may have your occupancy permit revoked. There was an ordinance out of a suburb of St. Louis that had that type of thing. Every tenant had to have an occupancy license to be able to rent a unit in the city. And if you violated this nuisance ordinance, your occupancy permit would be revoked, essentially banning you from living in the city going forward. It also may be on the side of the landlord where their rental permit, their ability to rent out that unit to anybody may be violated or may be revoked if they are found to have violated the ordinance. So they kind of range here, but a lot of times the penalty is passed on to the tenant where the landlord is required to take certain steps to abate the nuisance. And that can include significant fines or eviction of the tenant, or they may face their permit or condemnation of the property. Now, importantly, these protections or these ordinances are passed and typically have absolutely no procedural protection for tenants. We talk in housing circles about just cause evictions and wanting people to not be evicted willy-nilly for any little reason. We're talking about similar situations here with nuisance and crime-free ordinances, where folks can just be evicted without any type of due process or investigation. And there actually have been some landlords who have challenged these ordinances for that reason, also on due process grounds, saying that the state is basically forcing them to take certain action and that interferes with their business interests. So there have been some kind of creative ways to challenge these ordinances, but at the baseline, they require adverse action against tenants with very little protection. And they also have a very, very, very low standard of proof. One thing that really concerns me about these ordinances, especially when we think about certain communities that are over policed, that are known to have higher interactions with law enforcement, that are known to, have interactions with law enforcement where someone may be detained or arrested for not doing anything. And of course, no charges are filed, there's no conviction, but they may have been detained or may have a record of an arrest. Most of these ordinances do not require a charge or a conviction, they just require an officer response. So if you think about, that range of, I think the news was calling like living while black cases, where people were just having the police called on them for their kids selling lemonade on the street, or bird watching in the park. You think about all those times that the police have been called on black and brown people just for existing in this world. So having an ordinance that would then penalize that and a penalty so severe as to lose your home, these ordinances are really, really concerning to me in that way. So now getting to what that has to do with gender-based discrimination. So I promise there's a connection, aside from me just hating them. But really, the biggest target of these ordinances is not actually people who are creating a nuisance, but victims of crime, and in particular, survivors of domestic violence are significantly disproportionately harmed by these types of ordinances. Domestic violence itself has a disproportionate impact on Black women who experience domestic violence at a higher rate than women of all other races, and are also less likely to seek or have access to specific resources and assistance. And so these ordinances, by penalizing calling for help, you're either disincentivizing someone who is in a really serious situation who may need medical attention or may need police intervention, and saying basically making you choose between calling for that assistance and keeping your home. It also can penalize you even without any action. If you have a neighbor who hears an incident and calls the police, that may result in you losing your home. So there's been a lot of challenges to nuisance and crime-free ordinances, both on a disproportionate racial impact, but also a disproportionate gender impact, because people who are survivors of domestic violence are disproportionately women, and experience the impacts of these ordinances at a higher rate. So there have been some strategies for advocacy here, mainly on the state level. So California and Pennsylvania have created carve-outs for these nuisance ordinances. So it specifically says that victims of crime, domestic violence, and those who call for emergency assistance because they need it are exempt from, the general nuisance standard to help prevent them from being penalized with eviction. So I would check the laws in the books in your jurisdiction to see. These are very sneaky. And a lot of times they pass through without a lot of scrutiny because people think of nuisance and they think of, oh, a property that's really run down and the landowners don't pick up the trash, or a unit that's blasting really loud music at all hours of the night. They're not necessarily thinking about this type of language that limits law enforcement responses. And so a lot of times that language can sneak in and get on the books without people really noticing until it's too late and people are being impacted. So I'd encourage you to take a look at those. Okay, now before I get into VAWA, which is a little technical, any questions on nuisance and crime-free ordinances or anything else that we've covered so far? Okay, moving right along. Just double check our time here. Oh, we're doing great. Okay. So, the Violence Against Women Act. There's a lot here. There's a lot on the slides because, again, it is pretty technical and there are a lot of kind of complaints and forms involved. One thing I'll say is that the National Housing Law Project has done an incredible job of tracking VAWA in general. They put together an incredible guide, which I use for this presentation, on the changes from the reauthorization, the changes to the specific forms, and they also are consistently checking in with the housing justice community about how individual complaints are being processed, especially with this new, or not new anymore, but especially with our current administration and how things have differed. So they're a really incredible resource. Natalie Maxwell, specifically at the National Housing Law Project, is really great. If you have further questions about what it looks like to file VAWA complaints these days, I would highly recommend reaching out to her, and I'd be happy to connect you if that's something that you're interested in. Okay. So the Violence Against Women Act was passed and designed to provide protections for people who are experiencing domestic violence in housing and prevent them from losing their housing, essentially as a result of experiencing domestic violence. So in terms of who's covered under the Violence Against Women Act, you've got someone who is currently or has previously experienced domestic violence, and we don't just talk about kind of intimate partner violence. We're talking about sexual assault as well, other dating violence or stalking, harassment. Now, the survivor does not have to be married to, related to, or living with the perpetrator to be protected. And it also doesn't matter how long ago the survivor experienced the violence. So, having experienced it either currently or previously is enough to kind of meet that threshold. Some of the protections do apply to a survivor if they're applying for living in a shelter or transitional housing. So there's some technicalities there. And it also, interestingly and I think beneficially, applies to protected affiliates as well. So that includes spouses, children, parents, or siblings of the survivor, or individuals or tenants of the survivor's home. So that's kind of a nod to try and to keep families together and make sure that if you have somebody in the home who is experiencing some type of domestic violence, that's covered under VAWA, that their protections of how for their housing extend to anybody who's living in the household as well. There are a lot of protections here, again, and I'll be sure to share my slides after because I know there's a lot here. But there are a lot of protections for survivors under the Violence Against Women Act, which is great. The main ones here: can't be denied admission or assistance because of the violence or the abuse, can't be evicted or have your assistance terminated because of the violence or the abuse. You have the option, must have the option to stay in their housing, even if that violence or abuse kind of took place on the property. So making sure that just because, someone has a spouse who is living in the home and they experience domestic violence, they don't have to lose their housing as a result. It provides for emergency transfers. This is a really important part of the Violence Against Women Act protections. An emergency transfer for safety reasons, especially important in the case of stalking and things like that, or domestic violence where one of the perpetrator has moved out and is, still coming after the person who's experienced the domestic violence. Provides for continued assistance or continuity of that voucher if they are receiving one. Um, let's see what else we got here. It provides for confidentiality regarding the status of the survivor. It allows for lease bifurcation. So that's just a term meaning that if you have two people who are on a lease and one of those people perpetrates domestic violence, they can remove that perpetrator from the lease and be able to maintain their housing with that person off their lease. It provides for anti-retaliation provisions, similar to what we talked about with sexual harassment, and gives people the right to seek emergency assistance without being penalized. So again, tying into the ideas around nuisance and crime-free ordinances or rejecting the ideas around nuisance and crime-free ordinances, making sure that people have access to the resources that they need as a result of whatever they're experiencing. And then in terms of what HUD properties or what HUD programs are covered, because the Violence Against Women Act is tied to federal housing, it does not apply to market rate housing. So that includes public housing, housing choice voucher recipients, Section 8, Section 202, supportive housing for people with disabilities, HOPWA, home investment partnerships, continuum of care, ESG, Section 221, multifamily rental assistance, Section 236, and housing trust funds. So if someone that you're working with or client has housing protections related to any of these programs, the VAWA protections would also apply to them. So VAWA is reauthorized for 5 years at a time, and there are modifications that are made every time that it is reauthorized. In 2022 was the last reauthorization, and the biggest key takeaways were changes to specific forms that are used to file VAWA complaints or forms that are used in exercising someone's VAWA rights. So there are 4 forms here, and I'll talk about each of them and the main updates that were made to each form. Again, this guide is really the guide from the National Housing Law Project is really helpful, and I'd be happy to share that with anybody who wants to take a deeper dive. So the first form that was updated was a notice of occupancy rights, and this is just to provide a notice to anybody who is applying for VAWA covered housing to know what their rights are. And the key updates here is basically providing additional information to folks about what their rights are and how to exercise them. So it includes a new table that explains what constitutes a reasonable time for household members to continue to receive assistance. It includes examples of adverse factors or adverse actions and explains that they can't serve as a basis for denying housing as a result of being covered by VAWA. And it also specifically says that poor credit history and poor rental history that are related to being a victim of VAWA abuse cannot be a reason to deny an applicant. So, for example, if you have somebody who maybe does not have good credit because they weren't allowed access to having a bank account or something like that as a result of domestic violence or VAWA abuse, that cannot be used against them when they're applying for housing. It also explains that issues during the tenancy, such as noise complaints and property damage, cannot be used as a reason to evict, again, as a result if that action or that property damage or noise complaints are a result of abuse being experienced, and that applicants can't be denied housing due to their criminal record if it exists as a direct result of a VAWA crime. And that someone else's criminal actions, if someone is living with a perpetrator and that perpetrator experienced an eviction or removal because of their criminal activity, because it was directly related to domestic violence, the person who experienced the domestic violence cannot be denied assistance or housing as a result of the perpetrator's past eviction record or past criminal history. And lastly, it explains the process for an emergency transfer, and there is an emergency transfer form that I'll get to, so I won't go too deep into this, but essentially it just explains that people have a right to an emergency transfer if they're in VAWA covered housing and what the process is for that. So that's the notice of occupancy rights. And then there's also a model emergency transfer plan. So people or programs that administer VAWA housing are required to have a model plan just kind of on deck in case anybody needs it, so that they have a process for what would happen if someone requests an emergency transfer. There's a separate emergency transfer form that someone who is experiencing the domestic violence would fill out. This is on the housing provider side. It's a model plan that they have to have. And so the HUD 5381, there were some updates here about what that plan has to have and what they should continue or what they should continue to provide. And also it removed some boilerplate language. So essentially it provides some parameters here and drafting advice for how to create their own plans. Um, in terms of like how to request documentation. It also requires that this plan be available on request or be publicly available if that's feasible, and that these materials be available in alternative language and accessible formats. So someone should be able to walk into the office and request to see the model transfer plan, and if possible, it should be on a website or made available in various languages to people. It also requires housing providers to include a section for discussing priority in terms of how priority would be assigned to the VAWA protected tenant in relation to other categories of tenants who are seeking transfer. So that people, tenants want to transfer properties all the time. They may want to use their voucher somewhere else. They may want to move to different project-based housing. And so the plan has to explicitly provide for what categories of transfer applications would be prioritized and in which way, and specifically where anybody who's requesting an emergency transfer under VAWA would be in that hierarchy. And then lastly, it contains language about confidentiality requirements. And so it specifies that emergency transfers and information that's provided in those requests has to be kept confidential, and provides specific direction about record keeping practices that are designed to keep that confidentiality. It is very, 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 very important in domestic violence situations that perpetrators, if at all possible, are prevented from having the location of the victim or the survivor, particularly in cases of stalking, for example. And so it is really, really, really imperative on the housing provider to ensure at all times that confidentiality rules are followed to make sure that the survivor is kept safe, especially in an emergency transfer situation. Usually, that emergency transfer is related to a direct fear of safety or fear for the safety of the survivor and wanting to be removed from a location where the perpetrator could find them. And so, it's really, really, really important that housing providers follow the directives on how to keep location information confidential. Okay, and then HUD 5382 is a certification, basically the certification that a survivor would fill out saying that they were a victim of a VAWA covered crime. And so there were a few updates to this form, nothing super crazy, but specifies that tenants cannot be required to provide documentation other than what's contained in 5380. But it does remove some information about other acceptable types of documentation. It revises language around requesting an extension, and the new form just mentions that an extension is possible within the context of a disability reasonable accommodation request. And it also includes space to fill in the names of all relevant parties. So we talked about before, excuse me, protected affiliates. You can provide additional information there, and information for how to contact the survivor in a safe way. And it provides additional definitions for domestic violence, dating violence, sexual assault, and stalking to ensure that the individual understands what crimes or things are covered, and they can certify that they have been a victim or a survivor of one of those specific crimes that are enumerated. Excuse me?
Sarah, before you move further, we do have a question, and the
Oh, great.
question asks, does this also cover violence against males?
Yes.
It's called the Violence Against Women's Act, but it also does cover males who are survivors of domestic violence.
Yes. Okay, and then the last form is the emergency transfer request form that we were talking about before. So again, the modeled emergency transfer plan is something that housing providers are required to have on hand, for a plan of action in case someone requests an emergency transfer. And this is the form that the survivor themselves would fill out to make the actual request for an emergency transfer. So the updated form 5383, it explains that housing providers have the right to request documentation, and so kind of alerting the survivor, hey, if you make this request, Housing provider can request additional information or documentation of your situation to figure out how to move forward. And it does remove a little prompt that previously encouraged them to provide the documentation unprompted. It includes space to fill in contact information, again, to ensure safe communication with the survivor, and request more information about their housing preferences and what they're looking for in terms of how to provide them with an appropriate transfer unit. So nothing super crazy here in terms of changes from the last authorization to 2022, just a few little tweaks there. But again, this is the form that a survivor would fill out if they were looking to request an emergency transfer as a result of experiencing domestic violence, dating violence, stalking, or sexual assault or stalking. All right. And then in terms of the complaint process, if you filed HUD complaints on behalf of a client before, it's a very similar process. It's also filed with HUD. These complaints are investigated by HUD FHEO. Just a note here, expect significant delays in processing and investigation time given our current administration and the understaffing that's going on at HUD, as well as kind of change priorities there. The complaint must be filed within 1 year of the alleged violation, so the same kind of statute of limitations, again, for a typical HUD complaint. Potential complainants here are anyone who has or will be harmed by discriminatory housing process. So again, it doesn't just include people who have experienced the domestic violence themselves, but can be a protected affiliate or someone else who's experienced harm as a result of that discriminatory housing process, or a housing provider who has not followed the proper procedure under VAWA. And potential respondents can be a wide range. So any individual or entity that administers VAWA housing can be held liable for a discrimination complaint under the Violence Against Women Act. That includes public housing agencies, sponsors, owners, mortgagers, managers, state and local governments or its agencies, or non-for-profit organizations that administer housing that is covered under VAWA. In terms of the process itself, again, very similar to a typical HUD complaint. The complaint would be filed, it would go through an intake processing, it would then be investigated by a HUD investigator. There would be a conciliation attempt, which is just the HUD language for trying to resolve the case without further litigation. A settlement attempt, usually some type of settlement conference with an exchange of terms, and then HUD would make a determination, and there may or may not be legal action that comes after that. So the process, very similar, straightforward, but again, given where we are right now, I would expect that those complaints will take a longer time to process than the average, or than they may have under different administrations. And that is all I have, unless there are any questions.
Does anyone have any questions for Sarah? Any questions in regards to gender-based discrimination under the Fair Housing Act or the Violence Against Women's Act? Okay. I see a hand raised, Sarah. Renee, I'm gonna give you permission to talk. Hold on just 1 second.
Thank you. I'm sorry, and you may have addressed this earlier, but I'm just getting in at the last minute. I was on the HUD webinar. Is the um, Fair Housing Act being interpreted as protecting uh, those who may have a particular sexual orientation, or those who may be intersex, or not identifying as their biological sex or gender?
That's a great question. So, the Fair Housing Act, sex is a protected class. Sexual orientation is not specifically enumerated as a protected class. There are a lot of states and cities that have added sexual orientation to their kind of fair housing or civil rights statutes to create additional protections beyond what the Fair Housing Act says. That being said, there have been successful complaints about sexual orientation, basically arguing that sexual orientation discrimination is sex discrimination. We call this a sex stereotyping theory. So basically, if someone is identifies as male, the stereotype about that gender is that they would be attracted to women. And so if someone is not attracted to that woman or does not identify as male, even though they were assigned male at birth, they would be going against the stereotype of what they have been assigned. And that would be, and if they're discriminated against as a result of that, that's considered sex discrimination. So that's a long-winded way of saying explicitly sexual orientation not covered, but the argument is that discrimination on the basis of sexual orientation is really just sex discrimination. And so the arguments have been made under that protected class, even though it's not specifically in there.
Thank you for that.
You're welcome.
Thanks, Renee, for that question. Do we have any other questions? You can just raise your hand or you can put your question in the chat. It seems that we don't have any other questions, Sarah.
Okay. Well, feel free
Okay.
to share my slides and my contact info in case people think of anything after. And it was great to be here. Thanks for having me.
Okay. Thank you so much, Sarah. Thank you all for joining. This is just a reminder that this is a series that we're doing all throughout the month of April, as April is Fair Housing Month. Next week, you can join us on Thursday, same time, same length, and we will have a guest speaker, Eric Dunn. He will speak on eviction records and the Fair Housing Act. So you can come out again next Thursday, same length, to hear about it. Sarah, thank you so much for joining us today. Thank you all for attending today. You guys have some time to get back. So that we do think that you have enough time to finish your lunch, but we do thank you all for coming today. Hope we can see you all next week. Thank you again.